Hello everyone, thank you for coming out. On behalf of the Federalist Society and the Muslim Law Students Association, welcome to today's event. My name is Nadia Bandukta and with me is Ajay Kumar. And today's topic is Oklahoma's Sharia ban constitutional?
On November 2nd, 2010, Oklahoma voters passed the Oklahoma International Law Amendment, which required state courts to use federal and state law when interpreting cases and prohibited courts from using international law or Sharia law in making decisions. In January 2012, a federal court of appeals upheld a district court ban on implementation of Oklahoma State Question 755, stating, "The proposed amendment discriminates among religions. The Oklahoma amendment specifically names the targets of its discrimination. The only religious law mentioned in the amendment is Sharia law. Since then, however, dozens of state legislatures have proposed similar statutes. Our speakers today will debate the constitutionality of Oklahoma's bill."
Our first speaker is Rutgers Adjunct Professor Abed Awad. Professor Awad is an attorney, public speaker, and community leader. His practice is in New Jersey and New York and focuses on general civil litigation, including complex matrimonial law, commercial law, Islamic law, and international law. Prior to entering private practice, Mr. Awad was the law clerk for Honorable George Sabbath of the New Jersey Superior Court. Mr. Awad is an adjunct law professor at Rutgers Law School, Pace Law School, New York Law School, and Seton Hall Law School in Newark. He teaches 3 courses here: Islamic jurisprudence, Islamic banking and finance, and matrimonial litigation.
Our second speaker is Heritage Foundation scholar Hans von Spakovsky, a 1984 graduate of Vanderbilt University School of Law. Von Spakovsky received a bachelor's degree in 1981 from the Massachusetts Institute of Technology. Before joining Heritage in 2008, he served 2 years as a member of the Federal Election Commission, the authority charged with enforcing campaign finance laws for congressional and presidential elections, including public funding. Previously, Von Spakovsky worked at the Justice Department as counsel to the Assistant Attorney General for Civil Rights, providing expertise in enforcing the Voting Rights Act and the Help America Vote Act of 2002.
Each speaker will present for 20 minutes, followed by a 7-minute rebuttal period and a question-answer period moderated by Joe Bach. Thank you very much, and Professor Awad will speak first. Thank you.
Hi, thank you very much for the kind introductions. I'd like to thank the Federalist Society and the Rutgers Muslim Law Student Association at Rutgers Law School for sponsoring this event. In the spirit of the Federalist Society of the debate, as I understand from my colleague Hans, debate is also one of the primary methods of reaching the truth in Islamic jurisprudence. The classical tradition is replete with the disputation methodology between scholars and eventually trying to get closer to the truth. And I hope that today, that this debate is going to create more clarity on the issue for the betterment of our country. Probably sometime last year, I was retained by a left-behind parent it was a child abduction from the Caribbean to New Jersey. And during that time, the Supreme Court issued a decision titled Abed versus Abed. And in this decision, the issue was whether a nia exeat order, meaning an order preventing a parent to leave a country without the permission of the other parent, is tantamount to a custody order. This was relevant to my case, and as a thorough lawyer, client was paying well, so I had the ability to spend the time and to do the research. So I went and I obtained a copy of the oral argument of the Supreme Court. Now keep in mind, Abed versus Abed has nothing to do with Islam, Sharia, Muslim litigants. Has nothing to do with it. It's an abduction from Chile. In the oral argument, Justice Roberts asked the following question to the attorneys, and I quote, "So that if you have the mother taking her daughter from, say, a country where she would be forced to be raised under Sharia law." So even our Supreme Court justice automatically assumes that a Sharia law-governed country is something that is horrible, horrendous, unbearable for a female or for a child to be raised. So the misinformation, the distortion regarding Sharia, Muslims, and their culture is not only pervasive all over in mainstream America, it's even systemic in our highest court of law. And it's very unsettling to have one of our Supreme Court justices unable to take the time to maybe read about Sharia, understand what the concept means before making such generalizations. So the negativity surrounding Sharia is very serious and is fueling the Islamophobia around our country, which essentially creates disharmony in our civil society. A colleague of mine also, a couple of months back, sent me a journalism article from Columbia Journalism Journal. And in that article, it was a review of a Pew study about Islam in America. And in the Pew study, it found that more than double the people that believe that Obama is Muslim. So the misinformation still continues. In addition, the study found that Islam, Sharia, has negative connotations and that people equate Islam equals bad. Clearly, this misinformation is in one aspect as a result of ignorance. But also on another aspect, there is an intentional spewing of hate, misinformation, and distortion over the airwaves that is fostering this misunderstanding. This has led to this movement by people from the right, Gingrich and his ilk, to propose a prohibition and a ban on courts around the country considering Sharia in their decisions. This led to the drafting of the statute that's part of our discussion today. The Oklahoma voters voted to amend their constitution to include an express prohibition stating that Oklahoma courts are prohibited from considering foreign law, international, or Sharia. So Sharia is expressly listed in that decision. A Oklahoma resident, a guy with the same last name as I, but is not related to me, Mr. Awad, filed a complaint in district court alleging that this prohibition violates his freedom to exercise his religion. And the basis for that is that Mr. Awad had drafted a will, a last will and testament, that provides that at his death, the distribution of his estate would follow Islamic law. So he said, by this prohibition, my will judges in Oklahoma would be prohibited from probating my will. The district court agreed. It found that there is a great likelihood that Mr. Awad would prevail, that the prohibition does infringe on his right to exercise his religion. Therefore, the court entered a restraining order, saying, until there's a final hearing on the merits, the law is going to stay as is, no changes. Of course, an appeal was taken by the Oklahoma Attorney General, and the U.S. District Court, the 10th Circuit, affirmed the restraining order, finding that, one, the test that was used in the lower court, I mean, for anyone here, there are law students, you took constitutional law, you know the Lemon test, it's going to probably be on your final exam and on the bar. The Lemon test provides that there has to be a secular purpose that primarily does not inhibit or advance a religion and does not foster excessive entanglement in religion. And this was the standard that the district court below utilized. And it found that there was no secular purpose, and there was clearly an infringement on a person's religious rights. On appeal, the 10th Circuit said that standard is the liberal standard. it is not the strict scrutiny standard, and we believe that based on the facts, Lemon did not apply. It really was the Larson test. And in Larson, the legislation that discriminates among religions is only valid if there's a compelling interest, and that the compelling interest is fitted or narrowly tailored to serve that compelling interest. And based on that, the court said in the Oklahoma ban, it's really not between a religious citizen and a non-religious citizen. In fact, the ban was preferring one religion over another. So it's a heightened test. And based on that heightened test, the court affirmed the restraining order and explained that the likelihood of success that this statute is unconstitutional is very high. Oklahoma had no compelling interest other to say that Oklahoma is entitled to legislate and require judges only to consider Oklahoma law and not to consider foreign law. The court found that that generalization and that conclusion is insufficient to even reach a secular purpose or to reach a compelling interest. There was no harm identified by anybody in Oklahoma. There was not even one case in Oklahoma that had addressed Sharia. So now we go to this issue that the 10th Circuit clearly found that without a basis, we didn't even have to go to the second balancing test. But what's the whole paranoia about Sharia? Sharia, for most of you, it's similar to any other legal system. Sharia has more than law in a prescriptive sense, as we know in the common law system. Sharia has more of a methodology to engage the divine and foundational text to ascertain divine will. That process leads to fiqh, certain decisions, decrees that end up being the moral anchor for a Muslim's life. The way he eats, the way he drinks, the way you treat your parents, the way you distribute your assets or your estate upon death, the way you treat animals, the way you solemnize your marriages. It is everything about this moral anchor for a Muslim. So you have to be much more specific. And the 11th Circuit specifically said that simply saying Sharia is banned is so general, there is no way that it's narrowly fitted, even if there was a compelling state interest. So we have to be focused on this concept of Sharia that has become the boogeyman in our political establishment over the past couple of years is really over extended and creating much misinformation and distortion as opposed to creating an open dialogue and debate about the issue. So let's say one thing about America is that religious law and religion has been alive and well since our founding. It is pretty obvious that religion applies equally, just as the moral anchor to a Muslim, his religion and his Sharia, that applies equally to Christians, to Jews, to Hindus, because their religious principles are very personal to them, and they're very important. For example, very many Jews insist to go to rabbinical courts. Christians go to conciliatory tribunals. How about the political parties that we have, or the political activists around our country advocating against abortion or choice, capital punishment, position on gay marriage? Are those activists and those groups not infused with religion and with religious-based legal concepts that fuel their political participation? So this issue about religion being part of the public space is really normal. Now, how does Sharia come into play? So now we place the context of the Oklahoma thing, and now let me explain to you why it's much to do about nothing. Sharia can come into play only in two ways under our legal system. I've handled more than 100 cases, testified in 25 cases as an expert on Sharia around the country, and it only comes into play in two categories. Either Sharia comes into play as a foreign law, or it comes into play as what we would call extrinsic evidence or parole evidence. In the extrinsic evidence, parole evidence, what I mean is that you use this information to clarify an ambiguity, to explain a mistake, to reveal a fraud, to try to explain to the finder of fact in a trial or to this judge, what is the expectations of the parties to this deal? What were the surrounding circumstances to a deal or to a dispute. You use it to maybe uncover fraud or mistake. And I'm going to give you examples of both categories, the foreign law and the parole evidence. In the foreign law system, many Muslim countries around the world either have Sharia as a primary source or as the source of law for their legislation. Saudi Arabia is an example that Sharia law is the law of the land. So if Saudi law governs a dispute, it's Sharia law that's governing. Also, Egypt, Morocco, Qatar, most Arab countries, family codes are a codification of classical Islamic law. So an example as it pertains to foreign law. I'm going to give you examples of real cases. I'm not going to give you hypotheticals or abstract. I'm a litigator and a practical lawyer. So ExxonMobil enters into a joint venture with a Saudi company, SABIC. They enter into this joint venture. The joint venture was that SABIC has certain technology involved in the petroleum industry, and that SABIC will license this technology to ExxonMobil without any cost plus. No markup, no profit markup. Because of their deal, they work together, they don't want to pay an extra amount. 20 years into it, it turns out that SABIC, the Saudi company, was marking up the technology and was making substantial profits. The Saudi company, when they entered into this joint venture, they agreed that in the event of dispute, the document that would control would be Sharia law. So the case was pending in Delaware. The Delaware court had no option but to apply Sharia law because that is the law that the parties agreed to. The court elicited expert testimony from experts on Sharia to determine what are the elements of damages under Saudi law, because the court made a finding that the Saudi company violated and breached the joint venture agreement. One of the issues was the elements of damages. Under Saudi law, is there a consequential damage equivalent? Turns out that under Saudi law, there's something called enhanced damages, which would entitle you to recover damages arising from the breach, even though in future damages as well. The Delaware court entered an order somewhere in the neighborhood of $400 million in favor of the U.S. company. U.S. company wins by the application of Saudi law. If we had this ban, the Delaware court would not be able to entertain this litigation. And there are many other commercial settings, but now in the parole evidence setting. In the parole evidence setting, we would use two examples, both based in New Jersey. We have a groom and a bride. They get married in New Jersey. They're Muslim. They read Arabic. They understand their cultures and their traditions. They go to a mosque. They sign a marriage contract that says in the event of divorce, the husband is going to pay $50,000 dowry. Dispute arises. They go to court. The court has this document. It's never heard of it. It's called mahr. Judge doesn't know what this is all about. So now the court says, I need to understand what are the surrounding circumstances, what is a mahr, what is a Muslim marriage contract, how do Muslims get married, why do they pay this amount, what happens. The testimony then is utilized for the court to understand the expectations of the parties, and then the judge applies neutral principles of contract law in New Jersey. And the court says, was there offer, acceptance, consideration? Were there any incapacity? Was there a meeting of the minds? Is this contract enforceable under New Jersey law? In the case, the judge said yes. Same facts, but with a little bit of a revision. Let's say they did not read Arabic. They did not know what Islamic law provides. They show up. Husband is from Jersey. Wife is from New Jersey. They are, at the day of the wedding, they show him a document written in Arabic, say you have to sign. Now the husband is embarrassed. There are hundreds of guests. Doesn't know what to do. He's scared. He signs at the dotted line. Of course, when you apply neutral principles of law, the court will find there was no meeting of the minds because there was undue influence, there was overreaching, and so forth and so on. So in the end, in the parole evidence, the court is only taking this information to better understand the circumstance and then applying state law. There are numerous examples from around the country, but the politicalization of this debate is where these nuances and these subtleties are absent from the debate. So no one looks at them. How many minutes do I have?
Oh, about 3.5.
Okay, so I'm going to address Hans. He wrote an article last year, and I would take questions afterwards. And I'm going to explain to you to show that my esteemed adversary in this debate is missing the point, and he's failing to look at the legal nuances and subtleties. He states, to appreciate how strange a judge is, imagine if Oklahoma had passed a law stating that the state courts could not substitute Roman Catholic canon law for state and federal law. No serious person would protest that this has somehow inhibited Catholics in the practice of their religion. No one is asking for Sharia to substitute American law. There's a difference between saying Sharia is substituting U.S. law and that Sharia is being considered by the court. There's a difference between saying Catholic law is judges are prohibited from considering the law. There's a huge difference. Considering means that the court still has to consider it within the constitutional strictures of our country, which means public policy exceptions and other constitutional protections. Also, Hans also says that the First Amendment does not require courts to consider foreign law or replace foreign law. That also is not true. We have something called conflicts of law. That's American law. It says that if a tort takes place in Saudi Arabia, the law of Saudi Arabia is going to govern. If a contract is signed in England, that means England law is going to govern. If parties enter into a contract, our right to freedom to contract is a constitutional right, that I can choose the law that will govern my dispute. This is American law. So that's another miss. As it pertains to one particular case that is touted over and over, the New Jersey case where a court refused to enter a restraining order because a husband alleged that his genuine religious beliefs were he can have unwanted sexual relations at whim. That case has nothing to do with Sharia. Under New Jersey law, if a wife refuses to have sexual relations with her husband, or the husband, that's a cause of action for divorce. It's called sexual desertion. Under Islamic law, it's the same thing. If a wife refuses to have sexual relations with you, your cause of action is not to rape her, your cause of action is for divorce. So even though this person thinks he's genuinely entitled to sexual relations, that is contrary to Islamic law. The judge in that particular case made a mistake in New Jersey law. The statute for sexual assault under New Jersey law did not require a purposeful intent. Under the interpretation of the trial judge, he felt because of his genuine religious beliefs, he did not have the intent to make the sexual assault. The court said, as long as he knew she did not want to have sexual relations and he continued, that was a no in violation of the statute. So it was not, this case is not about Sharia, it's about a misinterpretation of New Jersey law. Finally, Mr. Hans says, neither Jews nor Christians are allowed to force their religious laws and views into our state court system as a substitute for the laws passed by our elected representatives. Capital punishment, abortion, same-sex marriages, what is that? Is that not the opponents to it on a religious basis? Also, just from New Jersey, Burns versus Burns, court had 5 rabbis and testified on the grounds of divorce under Jewish law and picked which one he liked to direct the husband to divorce his wife religiously. In Koloker versus Koloker, an appellate court remanded to the trial level to develop the record below on Mosaic law. These were 2 cases where Jewish law is actively alive just in the state of New Jersey. In the end, George Washington said, a nation that indulges towards another a habitual hatred or a habitual fondness is a slave. It is a slave, and somewhat a slave, either to its affection or its hatred, either of which are sufficient to lead the country and the nation astray from its duties and its principles. And I feel that the entire underlying purpose of the anti-sharia movement, they are slaves to their animosity. They're undermining our civil society. They're undermining our constitutional principles that make our country great. Thank you.
Well, Professor Awad has done a good job in trying to come up with the kind of spirited debate the Federalist Society welcomes. I did want to thank the Federalist Society for inviting me back and the Islamic Student Association for jointly sponsoring this, since you all had me here last year. And for those of you who attended last year, by the way, as you know, we debated immigration law. And you all should all know that that issue is going to be before the U.S. Supreme Court, April 25th, the very issue we were debating when Arizona's immigration law will be up for oral arguments. So if anyone is interested in that, you might want to check out the audio of that when it becomes available. I also wanted to quickly tell you, since you're all law students, that Heritage has an internship program. So if any of you are first years, second years, and you're interested in that, you should check out our website. And the big advantage of the Heritage internship program, unlike most other internships in Washington, D.C., is we actually pay. And also we provide housing for our interns. So if anybody is interested, go to our website. While I have great respect for Professor Awad, and we were actually comparing notes, we have very similar family backgrounds and experiences, I think he is doing something which is the real problem in this area, and that is confusing religious principles with the law. Okay, the referendum that was passed in Oklahoma said that it directed state courts while exercising their judicial authority to, quote, uphold and adhere to the laws provided in the United States Constitution, the Oklahoma Constitution, the United States Code, federal regulations promulgated pursuant thereto, established common law, the Oklahoma statutes and rules promulgated pursuant thereto, and if necessary, the law of another state of the United States. Specifically, and this is the part that caused such great dissension, the court shall not consider international law or Sharia law or the legal precepts of other nations or cultures. Now, I'll be the first to admit that parts of this were probably not quite put together the way you're being taught to do that if you're taking a course on legislation. But it's also true that among different existing bodies of religious law, the amendment only identifies Sharia law as impermissible, although that's not exclusive since it also talks about the legal precepts of other cultures. But it's only adherents of Sharia law who make comprehensive claims that it should supplant civil law. No other body of religious law does that. Now, some critics have made the erroneous claim that this law would have prevented courts from enforcing international treaties to which the United States is a party. That, of course, is untrue, because that ignores the long-established legal doctrine in this country that once a treaty has been ratified by the United States Senate, it becomes the same as domestic U.S. law. Professor Awad mentioned Munir Awad, who is the executive director of CARE in Oklahoma, who filed suit asking for an injunction. He claimed that he would suffer official disapproval of his faith, and he also said that it would cause problems with his will. I think both of those are claims that are not correct, and here's why I think why. Again, it's a profound misunderstanding of the requirements of the First Amendment and the practice of religion. Prohibiting foreign laws from being enforced in American courts does not in any way prevent anyone from practicing their particular religious precepts, whether it comes from their church, their synagogue, or anywhere else. The Establishment Clause was supposed to only prevent the establishment of a national church from being funded with tax dollars or forcing anyone else from being a part of it. I mean, James Madison said, and I quote, "Congress should not establish a religion and enforce the legal observations of it by law, nor compel men to worship God in any manner contrary to their conscience." To appreciate to me how confusing the judge's decision is, I would say to you that, if Mr. Awad, and that is the plaintiff in the case, not my opponent here, if he wants to practice his life by the precepts of Sharia law, he is free to do so. But what he is not free to do is to ask U.S. courts to enforce that law. And his will notwithstanding, that in fact is not the issue that was involved there. And let me tell you why I say that. If you want to write your will according to whatever your religious beliefs are, and I don't care whether you're a Christian, Islamic, or a Jew, then you can write your will to do that. If, for example, your religion, like the Islamic religion, calls for charitable contributions, well, then you can put that into your will. But when your will gets to court, what is the court supposed to do? The court doesn't look to the religious principles of your church to administer your will. The court looks to whatever the state's laws are on the administration of wills. Common law, as you all know, calls for the wishes of a testator to be honored. So, of course, whatever designations you have in your will, which you put in there because of the religious beliefs that you have, are going to be carried out. This difference between religious principles and the law is illustrated in another way. If a lender wants to structure a loan to a Muslim in order to satisfy certain Islamic principles prohibiting interest, the lender can certainly do that by writing the contract terms accordingly. You know, they can write out what your monthly payments are going to be to pay off the loan without including any notice about interest in the loan or anything about how they calculated the payments. But if a lawsuit is filed over the deal, over the loan, then what is the court obligated to do? The court is obligated to enforce the terms of the contract under applicable state or federal law that applies to loans. Not to enforce the contract according to what a particular religious principle is, or what a particular minister or rabbi or imam says the religious principles are that apply to a loan. Why? Because what does that do? That entangles our courts in our religions, the exact opposite of what the First Amendment says you're supposed to do. The very idea of adding a contract position that says that a court can resolve a dispute under Sharia law, I think, is very, very different from saying that someone, if they want to, when they're contracting, can use their religious principles to guide what kind of contract terms they will enter into. And Professor Awad mentioned the fact, he mentioned all these issues, abortion, many others. Well, no one says, and this provision in Oklahoma in no way prevents religion from being in the public square. I can practice my politics and do anything else that I believe is required because of the religious principles I believe with. And if I want to work at the state legislature, for example, to lobby them to pass legislation either for abortion or against abortion, depending on what my religious beliefs are, this law in no way would prevent that from happening. What it simply says is that my religious beliefs is not going to be what's enforced in the courtroom. The only thing that's going to be enforced in the courtroom is what the state legislature passes on that particular issue of abortion. Now, we have always made reasonable accommodations for religions in this country. Throughout American history, religious principles have served as a basis for decisions in many different concepts. But despite some of the examples that the professor gave, which I think were incorrectly decided, we have never asked the courts to enforce religious principles in our courts. What we've asked them to enforce are laws that are passed by our state legislatures and by Congress, and common law principles, because we're a common law nation and have a common law history, that have been developed over hundreds of years. Now, he mentioned the New Jersey case. This was probably the case that got the most attention around the country, and I would suggest to you all, if you want to see what it says, I'll give you the site quickly, and that way you can make your own decision on it. There's no name on the case. It's the initials SD versus MJR, 2 Atlantic 3rd 4112. And this case shows what happens when judges consider religious law or religious principles in a case. You know, the lower court judge should not have done that at all. And a provision like this would have put him on notice that he's not entitled to do so. Well, what was this case about? Well, the trial judge found that the defendant husband could not be held liable because he was exercising his rights over the victim, his wife, according to Sharia law. The plaintiff in the case was a Moroccan Muslim woman. She was repeatedly beaten and raped by her husband over the course of several weeks. She ended up in a hospital where a police detective interviewed her and took photographs of her injuries. They showed injuries to her breast, thigh, and arm, bruised lips, eyes, and cheeks, and there were blood stains on the pillows and sheets in her bed. When she sought a restraining order against her husband, he told his wife, "You must do whatever I tell you. According to our religion, you are my wife, and I can do anything to you." The judge allows the husband's imam to come in and testify that a wife must comply with her husband's sexual demands under Sharia law. And based on that, the judge would not issue a restraining order because he was acting according to Sharia standards, and that would supersede the standards of the law. Basically, it was used as a defense in that case. Now, fortunately, the judge was overturned by the appeals court, which said that they were wrong as a legal matter and offensive beyond words. The court said, quote, the judge had an unnecessarily dismissive view of defendants' acts of domestic violence and apparently believed, quote, they were culturally acceptable and thus not actionable. That is a view that we soundly reject. Just 2 months ago, there was a similar incident in Pennsylvania where a lower court judge relied on Sharia law to dismiss an open and shut case against a Muslim man who assaulted an activist at, of all things, a Halloween parade. The victim wore a zombie Mohammed costume in the company of another friend of his who was costumed as the zombie Pope, who was not assaulted. He admitted, when the man was arrested, he admitted what he had done, saying it was an insult to, it was a crime to insult the Prophet Muhammad under Sharia law. Now, instead of lecturing this man on the First Amendment, free speech, and how disputes are resolved in a civilized country, the judge instead criticized the victim for failing to appreciate how sensitive Muslims are about Islam and saying that he had gone beyond the First Amendment. Again, that shows the danger of bringing these kind of religious legal principles into a courtroom. And I see no problem with what Oklahoma did, because it didn't just, it may have named Sharia law, but it applied to all religious tenets. Now, on the case involving the large commercial case and Saudi Arabia, this provision would not prevent conflict of law provisions or choice of law provisions. Because obviously in that contract, the choice of law was not that Sharia law, which is this general religious law that applies in many different Middle Eastern countries and elsewhere. That's not what it said. What it said was the law, I assume, of Saudi Arabia would apply. Now, it's very true that the Saudi Arabian laws are derived from Sharia principles, but they are codified by the government, and once they are set out in the same way laws here are set out by our legislatures, well then it's statutory law, and there is nothing in here that prevent that from being chosen for a contract. I think the decision by the courts was an incorrect one. I think it confused religious principles with legal concepts and legal laws, and I see nothing wrong with the movement around the country to try to keep principles of international law over which Americans have no control We are a democratic country. The laws we apply here are those that are democratically passed by our representatives, and preventing international law, which is developed in other areas of the world where we have no control over that, I see nothing wrong with preventing that from coming into American courts. Thanks.
We will now move to our rebuttal period. Each participant will have 7 minutes. Professor Awad.
Of course, beating your wife, raping her, according to Hans, is part of Sharia. Here is where the distortion utilized by the proponents of the anti-Sharia movement, like Mr. Hans, where I've explained earlier that your cause of action for failure to have sexual relations is a divorce. It is illegal under Sharia to beat your wife. It is illegal under Sharia to rape your wife. In fact, there is reported cases throughout Islamic history that women were not charged with murder because they killed their husbands in self-defense. So this is where the general principles that Mr. Hans is talking about, he likes to keep the general picture about anything negative that a Muslim in his individual capacity does is related to his religious beliefs, and that's not correct. The wishes of the testator in Oklahoma is that in the event of his death, Sharia would govern the distribution. Sharia has a fixed share system that distributes the estate at death. That depends on who are the surviving heirs. So the surviving heirs would determine that. If a judge has a will that says the parties have the husband wants his estate to be distributed according to Sharia, how is a judge going to distribute it according to Sharia if he does not bring in expert testimony of what the inheritance law in Sharia states? Therefore, the ban in Oklahoma would ban him. And the district court felt there's a likelihood, and the 11th Circuit felt the same thing, that there is a likelihood, and there was clearly a specific religion targeted in the statute. The issue about the loans that are Sharia compliant in terms of applicable law that would apply. If you have a mortgage and it says that it would be governed by Sharia, of course that mortgage to be compliant in New Jersey has to also be compliant with the regulatory requirements of the state. That being said, at the time of a dispute, it means that the regulatory laws would come into play, but also Sharia would come into play to explain the expectations of the parties to the deal. So a Sharia law expert would be required for the court to adjudicate a dispute in such a mortgage dispute. Neutral principles of law is a concept established by our Supreme Court, and it's a very, very solid concept, over 40, 50 years old. Basically, what the court says is that even if a dispute is between a religious organization internally, or between individuals that want to be governed by their religious law, or a Muslim marriage contract, or a religious ketubah, whatever that document is, what the Supreme Court says, as long as you can apply neutral principles of law, that does not offend our Constitution. It is only when the court is going to entertain doctrinal issues in religious denominations or different religious perspectives that it becomes a problem. So the neutral principles of law is exactly what I've been talking about. When I say the extrinsic evidence, of course the court takes this fact finding about Sharia and then applies neutral principles of law, which is state law. In other words, everything that my colleague is discussing provides no added protection to any of our citizens. When you rely on belief, it becomes the law. That's not true. What happened in the New Jersey case had nothing to do with what my colleague had explained. The judge had an imam who testified that this fella, who is a batterer and who is committing more egregious violations of Islamic law than American law, stated that his genuine belief was that he can have sex with his wife when he told her. He didn't realize that she didn't want to have sex and that she was not consenting. That went to the direct issue of the intent. And the appellate court made it clear that there was no purposeful intent required. It had to be knowing. So it was a misinterpretation of New Jersey law, and it was not applying Sharia, it was applying the state of mind of an individual, which could be his religious beliefs, or his political beliefs, or his moral beliefs. Saudi law is not codified. That is a error on behalf of Hans. Saudi law is interpretation of classical Islamic law. In fact, the Delaware court relied on 12th and 13th century legal texts on interpretation of Saudi law. So it is not codified. The bottom line is we have to focus on the two categories that Sharia comes into play, which is foreign law and when you have a validity of a marriage issue come up. Let's say we have a couple who get married in Egypt. They move and they live in the state of New Jersey for 20 years. They have problems. They go to the court to dissolve their marriage for a divorce. Husband says we were never legally married. The court must entertain the validity of the marriage argument and to see, where did they get married? Well, they got married in Egypt. What are the rules and regulations regarding marriage? Well, they're Muslim marriages. And under Islamic law, this is what the codification of that Islamic law says. So the judge is taking into account Egyptian law, but Egyptian law is based on Sharia law. So therefore, the court must entertain Sharia to properly adjudicate the case before it. Now I'm going to give you an example that I handled where Sharia law came into play. Now, it's very important that you understand is that whenever Sharia comes into play as a foreign law or in extrinsic evidence, it's always within the strictures of our Constitution. So it's not supplanting our law. I work on cases where I testify that the court should consider Sharia because it does not offend our public policy. But I also testify in so many cases that the court should not consider Sharia because it does offend our public policy. So it's not a bright line rule. When you do bright line rules, black and white, you are robbing the judge from the ability to see the demeanor of the parties, to understand the surrounding facts, to better adjudicate the matter and to have a just outcome. Bright line rules lead to injustice. Bright line rules relating to Sharia inhibits Muslims from practicing their religion, prefers one religion over the other. And this is unconstitutional and unacceptable. How many minutes do I have?
1 more minute.
I'll give a fast explanation of this interesting case that I handled. Husband, New York resident, wife, British resident. They fall in love, long-range relationship. They decide the husband was worth hundreds of millions of dollars. They decided they were going to get married in Italy. They go to Italy, they fly a religious learned individual from Pakistan, they're Pakistani, and they solemnize the marriage in Italy. 5 years into it, one child, the wife wants a divorce, she files for divorce in England. Husband says we were never legally married. So while the case settled, the case turned on, was that marriage valid under Islamic law? And if it was valid, therefore all the rights and privileges arising therefrom would be due to the wife. The child would be legitimate, and she would be entitled to alimony, equitable distribution, child support, and what have you. So the courts in England had to entertain Islamic law, and I came into the case to argue that New York law would also govern because he lived in New York, and that the New York court would entertain Islamic law to determine if it was valid under New York law. And New York law takes a position as long as your marriage is solemnized, that's a legal marriage that is subject to recognition, and all the rights and privileges therefrom would arise. Therefore, depriving judges from the ability to consider foreign law and religious law as a blanket prohibition is contrary to 100 years of jurisprudence in our country and would result in inequitable adjudications.
Sure. Thank you very much to our participants. We will now move to our question and answer period. In your question, please be brief, state your affiliation, and provide your question in the form of a question.
Since you're filming
Yes.
us, do we need to speak at the mic or?
speak here?
It's fine, just please try to dictate loudly. The gentleman in the back.
Yeah, I'm a student at the law school here. Question is, do you think that the legislature, the state and federal legislature don't have what they need to pass laws that would support all the citizens regardless of religion or ethnicity or culture? Do you think that they're not capable of doing that? That we need to consider specific religious law?
No, but if you saw from what I said from the beginning, it is relevant under those two categories. That's the law of the land. There is no necessity, let me ask you this. I'm reading this interesting book. Thou shalt smite them and utterly destroy them. Thou shalt make no covenant with them, nor show mercy unto them. You must destroy all the people the Lord your God gives over to you. Do not look at them with pity, and do not serve their gods, so that they will snare you. Lord your God is giving you as an inheritance. Do not leave alive anything that breathes. This is from the Bible. And I can go through 20 verses advocating annihilation and genocide. Do I need a law in the state of New Jersey to say that these types of beliefs are illegal under New Jersey law? There is some common sense here that I think is lacking. If the law, if Saudi law provides for systemic inequity towards someone, no New Jersey court's going to recognize it. No U.S. court's going to recognize it. The purpose why Sharia comes into play as a foreign law or as parole evidence continues to be within the context of the constitutional restrictions. If it violates our Constitution, it is not the law of the land.
Then would you consider, how would you think of a law that says that no religion will be considered in a court as far as a defense to a crime or something like that?
But that's the law of the land. You do not need a law to say that. So the point being is by saying that you need a law to say that, you are, one, creating something that is not necessary, and two, the underlying purpose is you're trying to target one particular religion. So why do I need a law to say that if you rape your wife, even if your religion permits it, it's illegal? Number one, his religion does not permit it. And number two, even if any religion permitted it, it would still be illegal